Now, wasn't DynCorp involved with both sex trafficking and money missing from the Pentagon?
DynCorp was providing the anthrax and other vaccines to our soldiers. They were doing accounting for the Pentagon and responsible for oversight on $2.3 trillion that went missing on the day before 9/11, on 9/10/01. This money, $2.3 trillion, is announced by the Pentagon that it's missing. And the next day on 9/11/01, the accounting department of the Pentagon, with the accountants overseeing this money that's missing, blows up.
I thank the gentleman, the gentlelady from Georgia, Ms. McKinney.
Oh, thank you, Mr. Chairman. Mr. Secretary, I watched President Bush deliver a moving speech at the United Nations in September 2003, in which he mentioned the crisis of the sex trade. The president called for the punishment of those involved in this horrible business. But at the very moment of that speech, DynCorp was exposed for having been involved in the buying and selling of young women and children. While all of this was going on, DynCorp kept the Pentagon contract to administer the smallpox and anthrax vaccines and is now working on a plague vaccine through the Joint Vaccine Acquisition Program. Mr. Secretary, is it policy of the U.S. government to reward companies that traffic in women and little girls? That's my first question. My second question, Mr. Secretary, according to the Comptroller General of the United States, there are serious financial management problems at the Pentagon, to which Mr. Cooper alluded. Fiscal year 1999, $2.3 trillion missing. Fiscal year 2000, $1.1 trillion missing. And DOD is the #1 reason why the government can't balance its checkbook. The Pentagon has claimed year after year that the reason it can't account for the money is because its computers don't communicate with each other. My second question, Mr. Secretary, is who has the contracts today to make those systems communicate with each other? How long have they had those contracts? And how much have the taxpayers paid for them? Finally, Mr. Secretary, after the last hearing, I thought that my office was promised a written response to my question regarding the 4 war games on September 11th. I have not yet received that response, but would like for you to respond to the questions that I've put to you today, and then I do expect the written response to my previous question, hopefully by the end of the week.
Thank you, Representative. First, the answer to your first question is no, absolutely not. The policy of the United States government is clear, unambiguous, and opposed to the activities that you described. The second question.
Well, how do you explain the fact that DynCorp and its successor companies have received and continue to receive government contracts?
I would have to go and find the facts, but there are laws and rules and regulations with respect to government contracts. And there are times that corporations do things they should not do, in which case they tend to be suspended for some period. There are times then that under the laws and the rules and regulations passed by the Congress and implemented by the executive branch, that corporations can get off of out of the penalty box, if you will, and be permitted to engage in contracts with the government. They're not generally not barred in perpetuity. This
company was never in the penalty box. If you could proceed to my second question, please.
The second question, I've forgotten what the second question was.
Now, from reading your court transcripts, it was evident that not only did you do your due diligence, but that you escalated your concerns to the executives at Legato and EMC, as well as alerting the SEC. Could you elaborate?
I had asked my management and hadn't gotten direct answers. I raised and escalated my level of concern through management in my company. And at that time, the EMC-Legato merger had finished, so EMC was now the corporation in charge, and they weren't interested. So I went to the SEC. I called the attorney who was involved with the SEC's investigation of Northrop Grumman, and I said, look, I see the situation that you guys are investigating and arresting these people on. It seems similar to a situation that I have going on here. These are my clients. There are side letters with other clients that are going on that existed before I even got here. I haven't worked here long. I'm trying to understand the lay of the land. He indicated to me that if I shared any further information with the SEC, that I could be held liable and I could be sued and possibly worse. And it was not a warm and welcoming, hey, you're a whistleblower, come share this information with us. He was more telling me, if you proceed with this, we're going to make it hard on you because we don't want this information out there. Again, just like they don't teach the accountants and the lawyers about fraud, they didn't teach me, getting my business degree, about how to recognize fraud in these companies and what to do and what your rights are and what protections there are and what resources there are. And they certainly don't tell you that if you raise this question, you're going to give up a multi-million-dollar career because you asked this question and persisted in finding out the answer. And the protections you think you'll use to get that answer are actually, just there to get you to give that information so they could knit it up and tie up all the loose ends. The very person that I provided the information to in the form of blowing the whistle and requesting this specific protections engaged and provided by Sarbanes-Oxley was the general counsel of a multi-billion-dollar corporation that had just bought my company, and he showed vehemently that he was not interested in receiving this information because he ordered my termination instead of protecting me as the law mandates.
And when did you make this call to the SEC?
I made the call to the SEC on October 24th, 2003, which was my 30th birthday.
My impression from reading the court transcripts was that you didn't get what you expected from the SEC. What were your thoughts at the time?
Well, I was surprised because I went to them expecting to take this evidence and at least have them look at it and say, there's something here or there's nothing here. But when they said, you could get in trouble for sharing this with us, we don't really want to know about this. If it's going on and people are at risk, then, kind of so be it. And provably afterwards, soon thereafterwards, the SEC released a press release announcing that they were using Legato's email extender product to guarantee the integrity of their financial transactions and their records and all the auditing and all the audit trails that need to be there to work as in a transparent manner as they're supposed to do.
So how did the Sarbanes-Oxley regulations affect the pricing structure of the pre-existing email compliance software?
They sold the product in Europe, but they sold the product at a much lower price. And the product was, let's say, $18 per user here in America. So for a corporation that has thousands of people, they would have thousands of these licenses. And once the Sarbanes-Oxley regulations were passed, the company that I worked for, Legato, then raised their prices from $18 to $40 without adding any additional functionality. And in fact, that product had a backdoor that opens up all these other nefarious areas and areas of risk. So it was doing opposite of the job that people were buying it for. So all in all, there's thousands of companies that bought that product and that were potentially exposed without being able to have the benefit of being warned.
If I'm understanding this correctly, the Sarbanes-Oxley Act of 2002 mandates that so-called compliance software must be purchased and used across all financial services companies and beyond. So the question is, what new risks and/or blind spots were created and have yet to be identified as a result of the Sarbanes-Oxley Act?
The corporations not only had to buy the software, but they had a personal reason why they wanted to have the software, to preserve the integrity of their financial records, to guarantee that if they were audited, they would have the records to show any investigating agency, here, we're operating above board, here's all of our records, we're not running shell companies, we're not laundering money, here it all is. When you have a company that's investing so much money, hundreds of thousands of dollars, millions of dollars in this software, to prevent, their organization from being called on its integrity or impugning its integrity, thus having the stock go down in the news, they have this as a safeguard. So they invest all this money in a safeguard, and the safeguard actually is putting them more at risk. And as recent as last week, the Supreme Court indicated that Sarbanes-Oxley is fine as it is, and that there's no need to change it because it works perfectly for the purposes for which they put it there.